My name is Hannah Halbin, and I'm the VP of Human Resources at United Ag. And I host the Roundtable, the HR Roundtable sessions. And we do some of them in person, and it kind of petered out during COVID. But we came back in full force, and Maribel and I did a 1,200-mile road trip, doing our HR roundtables in person, and it was amazing, absolutely amazing. And so just recently we started our partnerships with Fisher Phillips, an incredible law firm, and they have deep expertise in all things legal for agriculture. And so we have two of our experts that we are blessed to have as our partners. We have Rebecca and we have Andrew, and I won't butcher their backgrounds. I'll let them introduce themselves, but they have agreed to partner with us on some of these really hot topics. And we have over 100 people joining this webinar, so it shows the need and the demand for these types of sessions. And we'll be sending things out afterwards. So one of the things that we like to do for the HR Roundtable is to make sure that you're spending your hour with us meaningfully, and you have a takeaway, something that you take back to your office, that you can say, that was an hour well spent. I have this checklist. I now have this tool that's going to benefit my company. So normally these sessions are more conversational, informal, but this is going to be a little bit more of a presentation. But please feel free to put up your hand, put questions in the chat if you do have any questions. Rebecca's and Andrew will be doing the presentation, but we're here to answer your questions. And probably if you have that question, so do the other people. So please feel free to connect either through the chat, or if you want to put up your hand. We have Maribel monitoring who has their hand up if there's a question. So with that, I'd like Rebecca and Andrew to introduce themselves, and we can get started.
Well, thank you so much, everybody, for joining us today. Hannah and Maribel, we really appreciate the opportunity to speak with your group here today. And obviously, this is very much a hot topic. If y'all have questions throughout the presentation, Andrew and I will be monitoring the chat. Please feel free to raise a hand, put a question in the Q&A. Our email addresses are also down here. Please feel free to reach out to us afterwards. We'd be happy to connect with you. I've been practicing at Fisher Phillips, primarily in the agriculture space, and I'm a partner here at the firm. We have an agricultural industry team that focuses on agriculture across the country, and we are very lucky in having a lot of great partners with a very deep bench and expertise in agriculture and the unique issues that you as agricultural employers face. So again, we're happy for this opportunity to chat with everyone today and look forward to getting your perspective on these different issues that are very much a hot topic in ag right now. Andrew, I'll let you take it away as well.
Yeah, thank you so much, and thank you for the introduction, Hannah. And folks out there, if you don't know Rebecca, many of you already do. But look, she's modest and humble. She is a chair of our ag committee at our firm. So she is one of the preeminent experts here. So please take advantage. And again, if you've got questions or comments afterwards, hit us up via email. But we got no problem with however you want to do it. I mean, if you're brave enough just to go off of the mute and show your face and ask a question in the middle of this, I mean, this is for you, right? So we create a PowerPoint that we think has prescient, current, up-to-date information, and it'll be helpful. But if you've got questions or need clarification, let us know. I won't give you too much of a brief background of myself, because it's not what you're here for. But I'm originally from Fresno, and prior to law school, I worked in the state assembly for the then chair of the ag committee. So it's near and dear to my heart. I mean, I grew up amongst it. After this webinar, I'm going to put on some jeans and head on out to Dinuba. So sort of the greater Central Valley and just ag generally is near and dear to me. And what we do is mainly employment law to help folks remain compliant, get compliant, stay compliant fight people who are saying you're not compliant, et cetera. All right, so we'll get going with that.
Perfect, Andrew. And we practiced the clicking and now it's going to give me, there we go. Okay. So just a quick overview, 10,000 feet view of what's happening right now in immigration in the United States. Since President Trump resumed office back in January, his administration has intensified immigration enforcement, particularly through USCIS ICE raids. Andrew and I were actually talking in preparation for this presentation today. We haven't seen, especially for our agricultural clients, we haven't seen much in the way of raids, but we have seen an uptick in I-9 audits. So we'll spend some time going through best practices on your I-9s and things you can do proactively now in anticipation of that potentially happening. There's been a nationwide enforcement operation that started back in January, intensifying immigration efforts. Those of you in the Central Valley and I think across the country potentially heard about some Border Patrol, Customs and Border Patrol activity that happened in Kern County actually before the Trump administration came into office, that had a lot of folks and growers in that area very concerned. So it's been a big shift in policy, and we've seen a big shift in just the overall temperature of our agricultural employees and concern focused on these immigration type issues.
Yeah, folks, and my takeaway from this slide, really, at the end of the day, like, look, I mean, we see it, right? Turn on the news, grab your cell phone, pick up a newspaper. Like, there is something going on with the administration, with immigration on a daily basis, if not more rapid than that, right? So, I mean, I'll leave the commentary aside in that regard politically, but it affects us. And the thing I would say about this slide right here is have a plan. Have a plan in advance. Okay, the last thing we want for our clients or potential clients is to just have ICE show up on your doorstep and everyone kind of look at each other, kind of baffled, befuddled, nervous, anxious, etc. So in terms of the raids and investigation, we just encourage folks to have a plan, and we can help. And we'll give you a preparedness action plan at the end of this, as Hannah mentioned, sort of a takeaway, right, that you can kind of check the boxes. So in terms of folks showing up, have a plan. And then, as Rebecca mentioned, the other thing that I like to let folks know is think about an I-9 audit prophylactically, because that's where we are seeing a lot of action take place. So the last thing we want there is to have the audit occur formally from the government. And again, it's sort of the same type of thing. We're looking at each other with sort of a blank stare and kind of hoping that we have compliant documentation, et cetera. So I think that's my takeaway game plan. Like, have a plan if ICE shows up, and consider an I-9 audit in advance.
Perfect. So we're going to go over a little bit about this. Always in California, in our state, right? There's a little bit of push and pull between federal law and what the folks down the street at the California legislature are asking of employers. So there was some legislation that passed back in 2018, the California Values Act, which bars our California or local enforcement from assisting the federal immigration enforcement. And there are some exemptions to that. For example, if an individual has a criminal record. There's also legislation that passed around the same time that requires that if an employer is going through a worksite raid, that employer require a judicial warrant for the employer to permit ICE, for example, to access the property. So the ways that ICE gets access to the property are either consent, you say, yeah, go ahead and come in, or they go ahead and get a judge and they do the legwork that they need to do to get this order that's on this slide, which will say order at the top. It'll say U.S. District Court at the top, and it'll be actually signed by a judge, and give ICE access to your property and to your workplace to search. And so in California, as California employers, we have to require that judicial warrant before granting ICE access to the property. And this can be particularly difficult for agricultural employers, right? We're not in a brick and mortar office where there's a receptionist and you go to them at the front desk and say, I'm here for my immigration raid. We're in fields, we're in packing facilities, we're spread across different geographical locations. So it's difficult for HR to be in all of these places all at once. And so just like Andrew was talking about, that's why it's very important in our industry to have that action plan and have that SOP in place now, and really be thinking about, okay, what are we going to tell our foreman if there is an immigration official that comes to them out in the field? What are their next steps? And really training those folks so it's, okay, I know who I'm supposed to call. I know what I'm supposed to do immediately. And we'll go through some of those things, but I would like to folks to take a look at what that judicial warrant looks like. Hopefully you have counsel and you can call them up and help navigate when you get a warrant like that, and you're training your foremen, your managers, your supervisors to go ahead and take a picture of those documents and be texting them so that you can get them over to counsel and we can be reviewing it as quickly and efficiently as possible. We'll go over this in a little bit more detail, but employers and employees both have rights, obviously, under the law, regardless of their status, of their legal status in the US. The Fourth Amendment, of course, protects people against unreasonable search and seizure of their home, person, and belongings. And then the employees continue to have the Fifth Amendment right to remain silent. I've seen a little bit of confusion sometimes talking to employers about that. We don't want to be, if an employee is exercising their right to remain silent, we don't want to be encouraging them or requiring that they participate in the investigation in any way, because they have that Fifth Amendment right, again, regardless of their status. Andrew, do you want to talk about this one?
Yeah, team. If you can go back just real briefly, Rebecca, because team, I want to point out, and Rebecca alluded to this, but it is absolutely vital from my perspective, because there is a lot of fear, anxiety, stress when ICE shows up, or when any governmental entity shows up. This worksite raids bullet point here. And Rebecca gave a screenshot, but I know some of us might be looking at it on a cell phone monitor. Some of us might, right? So it's a little difficult, but very, 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 very important here. Very important here, if I didn't mention that already, is to understand the issuing entity of the search warrant. Okay, so if it's a judge, if it's a court, and it's signed by a judge, that's one thing. If it's an administrative entity, it's completely different. All right, if it's signed by a judge, the auspices of a judge and a court, right, they're going to have permission to go into certain private areas as demarcated within the warrant, within this warrant. Okay, it's going to specify where they can go, but they can go. If it's an administrative entity, they can only go with your permission. So that's where the education of our folks becomes absolutely vital, and probably a quick call, et cetera, text message of the warrant, et cetera, to counsel. And Rebecca and I, or whoever you deal with, right, is going to be looking at it to advise on the spot, right? Because it's going to have to be instantaneous. We don't necessarily want to grant permission to an administrative entity, an entity that has a warrant that's an administrative warrant and not a judicial warrant. Very, very, very different. All right. So I just want to highlight that. It's absolutely imperative in the first instance for whomever receives this warrant to understand and appreciate who issued it and the scope of it. All right. I don't know if anybody's seen the movie Sinners yet. Normally not my type of movie. Okay. Rebecca's saying no, and I don't see anyone else. Look, it's like barnstorming through the box office right now, but it's like vampires, right? And I didn't think I'd talk about vampires today, but you apparently in vampire lore, you have to grant them permission to come onto the site, right? That's how you can remain safe. They have to have permission. Lo and behold, it's just like ICE, okay? Not to call them vampires, etc., but it's the same thing. They have to have permission if it's an administrative warrant. They don't need permission. They have judicial permission if it's a court. All right, so very, very different. All right, thank you, Rebecca.
A very good point. So we'll show you an administrative warrant in the next slide here, so you guys can kind of get a little bit of a sense. They will look a little bit different, unfortunately, from court to court to court, but the main, I would say, three things you're looking for is it says a judicial warrant is going to have the name of the court at the top of it. So like this one, it says United States District Court, District of Minnesota. It's going to say order, and it's going to have the word warrant in the order. It probably will have a case number there that you can reference, and Andrew and I can on the back end look up and talk to the court about and confirm the validity of that warrant. And then it'll also have the judge's name and signature down at the bottom, just like this one does. And it'll outline where they have permission and the scope of that warrant. And then let's jump to the next one so you can see what the difference is between that administrative warrant. This one, and we'll circulate this slide deck after. We'll ask Hannah and Maribel to go ahead and circulate this slide deck for us so you can have these as reference materials afterwards. This is an example of an administrative warrant. It says, instead of saying a district court up at the top, it says U.S. Department of Homeland Security. That's how you know this is issued administratively. It's not signed by a judge, it's signed by an immigration officer. So those are the key differences there. Andrew, do you want to jump into the magic words here?
Yeah, thanks, Rebecca. And team, again, this goes to sort of education of the workforce generally, not only necessarily like foremen, et cetera, but also workers, because in certain circumstances, it's going to be those individuals who have the opportunity to protect their rights and really protect the business, the employer, the entities, et cetera. So again, Fourth Amendment, that's the search and seizure. The straight up words right here that we want coming out of someone's mouth, presumably is am I free to go? Or conversely, am I being detained? Because if somebody is free to go, then they can proceed, they can go, etc. Right? If they're being detained, that's where I would strongly recommend as counsel to anybody, any client, certainly, to just keep your mouth shut. That should, if you are detained, you want to proceed to the Fifth Amendment. Don't incriminate yourself. Don't talk about what country of origin, etc. Right? Exercise that right to remain silent. If you're free to go, go. Right? If you don't know if you're free to go, and ICE shows up and everybody starts running to the exit, we're probably going to have an issue, because the running to the exits, right, provides the reasonable suspicion that law enforcement needs to kind of step up their antics. Okay, so if any individual is speaking to anyone, right, and they're uncertain, the magic words are really just am I free to go, or conversely, am I being detained, right? And law enforcement will need reasonable suspicion in order to detain. But things like running to the exit can often provide reasonable suspicion. Okay, so that's sort of the first demarcation, is understanding there's a big difference in status of you're free to go or you're being detained. And then the Fifth Amendment comes in. That's the right to remain silent, the right against self-incrimination, et cetera. We want folks generally, I mean, we can educate folks. We can tell folks about their rights, et cetera. We can't necessarily enforce them for them. But generally speaking, right, we just want folks to understand that they always have the right to remain silent. Always have the right to remain silent, right? The communications with any of our individuals, certainly if they have reason to believe that they have immigration status issues, et cetera, their communications should be with counsel, right? It should not be with law enforcement. That usually doesn't go well, right? Law enforcement is not prohibited from lying, stretching the truth, coercing in certain ways, etc. They're trained in those tactics. And so the right to remain silent is what we want our folks to understand. And here's the difference that we talked about briefly again with an administrative warrant versus a court warrant. A court warrant, right? And there's some bullet points there that talk about those differences. Again, the ICE warrant doesn't authorize those agents to enter without permission. Okay, and so that's where we want our folks to understand and appreciate. If it's that administrative warrant, it's like, stop, thank you, we'll accept it. We'll probably call counsel on the side, but y'all need to stop and stay where you're at, right? Until we have understanding probably from counsel about how we're going to proceed. So the ICE warrant, it looks official. It is official. It looks important. It is important, but it's many grades below having a court judicial signed warrant. And in order to protect rights, we need to understand what those rights are with that ICE warrant. Yep. Any questions, comments, or concerns right now about this? I know it's a lot, but the distinction is pretty vital. So I want to make sure we're all clear, good to go.
I think to the extent you have operations that are happening offsite, for example, foremen out in fields where maybe if they're confronted with an immigration officer, the magic words for them is, I don't have the authority to accept documents on behalf of the company. I'm going to need to call, and this is why training beforehand is so critical and so important. I'm going to need to call my rapid response person who is so-and-so, and I'm doing that right now. And limiting the scope of what they're telling the officer and what they're engaging in. But those are the magic words for your foreman until you can get, and this is all going to be happening quickly and in real time, but you need your emergency response person on the phone to be giving your foreman instructions. The magic words for them are, I'm not authorized to accept documents on behalf of the company. And then you can move on from that point. They should know to be contacting the emergency response person. The next slide is a bunch of different resources. Fisher Phillips also has some resources as well. One note on the Know Your Rights for Employees side and Know Your Rights If You're Stopped side for employees. You are not handing these to specific employees, and you are not encouraging employees to speak with you individually about their immigration situation. You have an I-9 if you have hired this person and if they're working for you, that you are standing behind. It went through your I-9 process and your I-9 SOP. We as a company are standing behind the validity of that I-9. So we are not offering individual immigration advice or individual what you should do, but you can provide, and I have some agricultural clients who have provided what you should know type pamphlets, and you hand it out or you provide it in a common area. This is information for friends and family if you're interested. We're not handing it out to individual employees. Employees can go and grab it. We're not monitoring who grabs that pamphlet or grabs that flyer. And it could be for family members or friends for all we know. It's information for you, because we don't want that constructive knowledge about an employee's unlawful status, because then you have to do something about it, right? So all of this information and this training is done on a wide net basis and without any particularization at all. Okay, so let's get into the differences between an ICE raid and an ICE audit. An ICE raid is a surprise enforcement action where ICE is there unannounced. You have no notice that they're coming beforehand. They're entering the workplace. For our purposes today, the workplace, will focus on that, to detain individuals who are suspected of being undocumented. They're typically there to arrest people for possible deportation. They're typically there for specific individuals that could be listed in that judicial warrant that we showed you earlier. Again, there's no prior warning to the employer or individuals. This is the thing we want you to have an SOP and do some training for your foremen, supervisors, managers on ahead of time so that folks know what to do if this happens. The other thing is it's 3 days, so it's real fast, right? But it's a little bit more of a slow burn. It's an I-9 audit. So this is a review of an employer's records, specifically the I-9 document, to ensure that all employees are legally authorized to work in the US. ICE can come on your property and give this audit form to you in person. So this is why it's important for your frontline folks to be trained on asking, why are you here? So you have an idea, is it just an I-9 audit? In that case, we want you to give us the document and we want to be able to send you on your way as quickly and efficiently as possible. Or is it the ICE raid where we're following that different SOP? It's not a lot of time. Again, it's 3 days, but at least you have a little bit of time to review the I-9 audit. Okay, let's call our counsel. Let's get ready to produce these documents. You don't have to do it that day. And I have employers that have the binder ready to go to turn over to immigration that day. You want to go ahead and take advantage of that little bit of time to review the documents and make sure they're ready to go before you produce them. Sometimes these work in tandem with each other. Sometimes an I-9 audit is a prelude to a raid, but much different timetables for these. I think Andrew and I already mentioned that I-9 audit is what we're seeing a little bit more of as compared to the raid, but that could change it at any time. Anything else to add to this one, Andrew?
No, that's great. And we'll review this question here from Nikki. Again, folks, I just want to say, again, I just want to echo one more time that I-9 audit, that's a formal ICE audit, right? A lot of companies will choose internally or to use counsel to do a self-audit prior to that happening, right? Because I think the penultimate bullet point there was there are possible fines, et cetera, or right, for certain documentation or lack thereof. So, you know, if you suspect that, wow, maybe we were lackadaisical about this, or we're just kind of concerned about sort of the heightened attention in this area, especially with our industry, right? It might be an opportune time to think about performing an I-9 audit prior to ICE knocking on the door and saying, we are auditing, right? And then let's see, was it in the chat? That I think it popped up. So I'm just going to read this out loud, Rebecca. We can handle it impromptu here. Nikki G, thank you. What happens if the warrant has an address of office? The ranch facility is a different address. Is the warrant address location specific, or is it company specific?
My response would be that the address would be the address where listed in the warrant itself. So you'd have to give the officer access to your office if the address was the office. If it's a field address, we would expect to see the field address listed in the warrant itself. Andrew, I don't know if you have any other thoughts on that one.
Yeah, 100%, Rebecca. So first of all, again, let's have processes in place, right? Rebecca mentioned, you know, standard operating procedures about who receives that actual warrant, who's reviewing that actual warrant, as you snapshot it and send it to like counsel to try to do simultaneously, right? But the warrant should specify, right? Warrants are hopefully not these vague, ambiguous documents, right? That just say we're going after such and such ranch, right? Or we're going after such and such company, or we're going, right? It should very much specify what is subject to the warrant. And so it should specify within there. And to Rebecca's point, right? If it specifies an address, then it should be that address, right? Not other fields associated or other areas of the company geographically, et cetera. So it's very important to understand the scope of the warrant, and the warrant itself will specify. That's why, at least maybe this is not always the case, but generally speaking, the court ones are a little bit better in that regard, because a judge who is a little more cognizant of the law and the legal parameters and the need for the specificity of a warrant, right, will specify. I think the administrative ones might be a little bit more difficult, where it's just an officer who's executing it. But yeah, great question, Nikki. It should very much say within the warrant what the scope of it is, right? If it not, it would be kind of mayhem for everyone.
I talked to a few different, this is a question that comes up quite a bit. Like, what if the warrant, it's a judicial warrant, we've gone through our SOP, we're at the point where we've confirmed this is legitimate, it has a specific individual listed, and say we're a nursery and there's an office, and then behind us there's 10 different greenhouses, and this person is probably in one greenhouse. Are we going to ask where are we going to let the immigration officer go into all of these greenhouses? And then our other employees potentially see this immigration officer, get very concerned and run, and to Andrew's point, giving potential probable cause for further investigation into those individuals who are running for whatever reason, because they're scared, because they don't want to be a part of what's going on, whatever the reason. Few different schools of thought on this. I think most immigration attorneys that I talk to say maybe go ahead and bring that individual to the office, so you're not granting ICE access to the whole of your operations, or to an entire greenhouse, or to an entire field. But that's a great question about the scope, and really making sure you're working within the confines of what's in that judicial warrant. Our field locations are obviously not going to have an address. You know, you're plugging in a pin on Google Maps and trying to get to that pin. I've been there many times, and it can be a challenge, but usually like for example, in your H2A applications, you're having to identify in some way, whether it's cross street or GPS coordinates, some type of field location. We would expect some level of specificity for a field location in a judicial warrant for a field.
Yeah, that's great, Rebecca. And then Alicia Ponder followed up here. Good morning. Our business is located on private gated property, and you can only enter with a code. Do we only lead them to our office and no other places?
Yeah, I think the office is a great place. Just like if you had Department of Labor coming, you generally would say, can you come to my office and we'll talk, I'll get my rapid response person here and we'll talk through the scope of what your investigation is. I would say if it's just an I-9 audit that they're there to do, I would ask them what they're there to do and show me the document at the gate. If it was just an I-9 audit, I would say, okay, I got it, and then let them go at that point respectfully. They don't need to come into your office to give you that document, and you don't need to concern all of your employees with a CBP or an ICE vehicle coming up the driveway through the gate. I would just handle it at the gate if that was possible.
Yeah, absolutely. I concur with that 100%, Rebecca. I think that's great advice. And then the other thing, Elisa, is if it's also if it's not just an I-9 audit, right? But you have a warrant. Again, now's the point at that gate while ICE is still on the wrong side of your private property to determine whether or not it's a court warrant that permits ICE to come onto private property, right? Or an administrative one wherein they need permission. Right? Because that's at the point where somebody, hopefully the right decision maker, is making the decision as to whether or not to, again, I hate the vampire analogy, like I'm not into scary movies, etc. I just saw it over the weekend, but it needs permission, like they need permission, right? And so that demarcation of private property is very, very important if it's an administrative warrant, because they don't have your permission yet. They don't have legal authorization to come onto your property yet.
That's a great point, Andrew. I've had some confusion in the past, like, is our office a public space? Then there can be some confusion with tasting rooms that are right adjacent to fields, for example, where that tasting room, we want the public to enter. Yes, that's a public space, but that field right next to it is not. We wouldn't let a member of the public go onto that field for a whole host of reasons. But we'll jump into this in a minute, but hopefully folks have no trespassing signs already up for union issues, for example. There's a whole multitude of reasons why you would want no trespassing signs up, but hopefully you have those in your fields and your private workplaces. So with that, I see another question coming through.
Do you want me to cover that for? If the warrant is employee specific and the employee is not at the office, which is the address on the warrant, what is the proper communication to the agent? As an employer, we want to work with authority, but we also want to protect our employees. Do we give the authorities the details, or do we simply say that the employee is not at this location? How much do you say, and how much do you allow your attorney to handle?
I think in that situation, I would definitely contact your attorney, and we'd probably want some more fact-specific information about what the subpoena said. In determining its validity, I would expect there to be some language about the employee and where they work and the different work sites listed in the warrant itself. But that's a situation where we'll probably get your counsel on the phone to work through the proper next step. And it's always appropriate to invite, if they have a judicial warrant, right, and they have access to your property in the office, to permit the ICE officer to go into the office, maybe give them a conference room or an office if one's available. Never leave them. We'll get into this in a minute, but you're not leaving them alone. They're accompanied by company personnel at all times while they're on the property, while you explore the scope of that warrant and the particulars of that fact-intensive situation. So with that, let's get into the different types of inspections. We went through why would ICE be at the work site. They can be there to start an I-9 audit, give you that document notice of inspection. The goal there being get that document and let them, with respect and with cordialness, let's get you off the property as quickly and efficiently as possible. a workplace raid, you're going to be looking for that judicial warrant to detain a specific person. They also are going to need to have that judicial warrant. Andrew and I have really been hamping on this, but it's worth mentioning again. Training is the most important thing here. How employees react can really dictate how well a raid goes from an employer's perspective. So training is the most important. No matter how much training you do, folks are going to be nervous, folks are going to be uptight. So the more we can have open communication with foremen, managers, supervisors, and HR, whoever is likely to be responsible for interacting in advance, the better. Again, I think of this as magic language for your staff, for your receptionists. They should all be prepared for this. I can't give you permission. It's not within my authority. Please go to the office. Or I can't give you permission. I can't accept documents on behalf of the company, but I am calling my rapid response person if they're out in the field. And then being in communication with phone trees so that everybody that needs to know in the company is being informed as quickly and efficiently as possible.
And while we're in transition, Rebecca, I just want to note, someone put in the Q&A a question that I think we'll address shortly here once we get to the durational time frame for preserving records, et cetera. But someone asked, if you have employees for about 10 years, we've held onto their I-9s for that long in preparation for an audit, should we update their I-9s so everyone is up to date and falls within a 3-year window? So, okay, I think Rebecca wants to answer that one right now.
No, we'll get to a calculator in a few slides. So let's keep rolling here. But no, you shouldn't update someone's I-9 if they've been working for you. There's certain reasons and particular circumstances why you would need to, but generally once you have the I-9, you don't touch it again unless the employee is on some type of expiring work authorization. I think the main takeaway I want everyone to take from this slide is we're not leaving the ICE officer once they're on your property. Someone, even if it's not your point person, and we're waiting for the point person to get there, is staying with the officer and documenting exactly what they're doing, monitoring their activity on site. We're not releasing information about client, staff, or others unless the warrant specifically requires you to do so. It could require you to hand over documents. If ICE does take documents, you're writing down and documenting, like an HR professional always knows to do, document. You're documenting what they're taking so that you have an inventory of it for yourself internally while we're dissecting what has happened after the raid is complete. Running away could of course give ICE a legal reason to go ahead and arrest workers, and that's why doing the training prophylactically beforehand is so important. When there was that CBP activity down in Kern, that was one thing that I did hear was, there was, I think, an active pursuit, and this is a story that I've heard from an association, but that there was a CBP officer who was in active pursuit of a specific individual. They ended up driving through a grower's property. All of the workers saw a CBP vehicle and immediately ran. It's going to be impossible to stop that, but I think the most training we can do and assurances that we are going to follow and be in compliance with California law. The only reason we would be permitting ICE or an immigration official onto the property is if they had a valid judicial warrant. That can give employees some reassurance that you are going to be limiting their interaction with CBP, and you wouldn't give access voluntarily, which you're required to do under California law anyway. And then of course employees have the right to remain silent and ask to talk to their lawyer and their counsel. This is another area where there's a little bit of a push and pull. UFW immediately after the activity in Kern County was out with employee rapid response sessions and informational sessions, and there was such a thirst and hunger because of the craze on social media for information for employees, and employees were hungry for that information, and some were staying home because they were scared about going to work and scared of being arrested regardless of their immigration status. So doing some training prospectively, I think can be important, especially for your frontline managers and supervisors, so they have that level of comfort that can be disseminated down into your general workforce. So documenting the encounter, you're following the ICE agent during the inspection, you're writing down the date and times that things are happening, you're asking for names and badge numbers of the officers. It's okay for you to take pictures of what's happening. You're writing down what agency the officer said they were from. This is happening as soon as they come onto the property so that you can be working with your rapid response team and your council on what the requirements are for what you need to do in response to who they are. California is of course a two-party consent state for recording. So if you are able to record a video from a safe distance, that's okay. But also announce that you are recording and try to get that announcement in the video if possible so that we can show, just like Zoom does, we're recording, just to let everybody know, then it's captured in your video that you let folks know you were recording ahead of time.
Yeah, folks, I just want to iterate how important this is, right? I mean, everything we talk about is, right? But documenting this process with ICE on site can be invaluable later on, right, to your company or your organization. And I get it that a lot of us, maybe most of us, are deferential to, you know, law enforcement, the administration, et cetera. Like I get that. I'm empathetic with that, right? I have a long line of military and law enforcement in my familial background. So I think a lot of us are naturally deferential and we want to seem polite and respectful and answer questions, et cetera. But that approach can sort of attenuate this process. And this is just saying, hey, look, we want to document it because quite often an inspection, a raid, et cetera, can go beyond the scope of the warrant. And that gives a lot of legal leeway for us in the defense of this type of thing or in a response, et cetera, if we have that information. And if we don't have sort of the documentation from the company or the organization, et cetera, we won't be able to do that. And then lastly, on that one, Rebecca had on that slide, the bullet about announcing that you're recording a video. Again, that's important legally in the state of California specifically. I think most other states have it now too, where like we have, you know, you get an announcement that we're recording this webinar, right? Because by virtue of staying on the webinar, you've consented to it, and so will ICE, et cetera. So if we can document, you know, again, respectfully, et cetera, at a safe distance, not in, you know, not getting in the way of anything, et cetera, it can be really, really, really important. Despite the fact that it may seem adversarial and, you know, you may be adverse to doing that because you may think like, oh, well, it may seem more suspicious, et cetera. It doesn't, right? It's just an objective way to document what occurred.
With that, I think we'll go ahead and jump into I-9s. I'm sure you are all I-9 experts, but I will say in our industry, the I-9 is a tricky document. I think we say this a little bit later on in the presentation, but it's a over 200 page how-to on the I-9. Whatever one-page document has 200 pages to explain it. It's a little bit complicated, right? So it's a great time because of the focus on immigration right now to do either a self-audit or to go ahead and hire counsel and work with counsel on a small self-audit. I've had a few clients go ahead and do this, and we've been able to spot just little ticky-tacky errors, clean them up. It's always possible. You don't even necessarily have to have the employee come back and do a whole new I-9. You can do a correction per a self-audit, and that can save you a little bit of heartache on the penalties on the back end if you are hit with an I-9 audit. So we'll breeze through some of these basics here. Who can work in the U.S.? Obviously, citizens of the U.S., non-citizen nationals of the U.S., lawful permanent residents, and non-citizens authorized to work. Some of you may utilize the H-2A foreign guest worker program. That would be an example of that. An individual who is a non-citizen authorized to work in the U.S. for a certain period of time. So there's two sections, a section 1 to be completed by the employee no later than the start date of employment. I think there's sometimes a little bit of confusion on that. I don't know if you see that, Andrew, but you have to complete section 2 by the end of the 3rd business day. Section 1 has to be completed by the employee no later than the start date of employment. So that's something you have to get done right away. So it's a best practice, and I encourage folks to just go ahead and do the I-9 on the first day. That way, if they don't show up on the second day or the third day, you have the I-9 done and ready to be in your file. You can complete it, of course, prior to the start date if an offer of employment is made and accepted.
I just want to know while we're transitioning here, Rebecca, the question, and we'll get to the documentation and updates, et cetera. And Rebecca already answered one question and alluded to that, but someone is asking here if even though the I-9 form has changed over the years, does a company need to complete or update sections of the I-9 if the original? And again, you're given the same answer there, right? As you're shaking your head, no. So I'll just defer you on that. But team, I think Rebecca already alluded to. We're not going out of our way to make changes on the I-9 forms or updates, right? Unless we need to. So I'll defer to you there, Rebecca, to finalize that.
Yeah, so if the new I-9 form comes out, that applies to folks that you're hiring in the future. If you are seasonal and you're having employees complete a new I-9 every season, you would go ahead and use the new form I-9 for that. But if you have a year-round employee and they don't need to go ahead and complete a new I-9 for that. Andrew, do you want to talk on this one?
Yeah, folks. So look, from my perspective, again, it's vital that we properly train our people who are going to be doing this, right? Because section number 1, employee, section number 2 is us, right? And so it's vital that we just have a uniform process and a legally compliant process. So look, it goes without saying we can't discriminate. Look, none of us are going to say, oh yeah, our organization discriminates, or the person doing it is going to say, oh yeah, I discriminate. But what does that actually mean? It means, look, when we have a list of acceptable documents and we've got list A, list B, and list C, right? It is up to the employee to decide whether or not there's going to be one list A document or a list B and a list C document. And if the latter, which item on list B and which item on list C, okay? Every once in a while, we'll hear some bad information or a narrative or a story where the employer thought it was a good idea to ask for a specific document. It's not a good idea. It's an illegal idea, right? It is up to employee choice as to what documents to present. Also, if somebody presents a document that's in list A and shows not only the proof of identity, but also eligibility to work in the United States, one and done, and we don't need to proceed to acquire other documentation. Same thing if there's one document that we think is reasonably valid for B and one document for C, we don't ask for additional documentation, right? That can sort of get us into trouble. I mean, the more documents that are provided, the more opportunity that something goes awry. And so we're just doing what is minimally compliant. I know that sounds odd to say, right? Normally, in every aspect of the way we operate our business, we don't do what is the minimal to comply, right? We like to go above and beyond, but above and beyond is not good for your I-9 document. So I think the next slide actually is helpful in explaining that if we can. Yeah, thank you, Rebecca. So the one on my right, the list of acceptable documents, no need to memorize that, right? It's published. It's up there. DHS has that published. It's easy to find. If you can't find it, let us know and we'll ping it over to you. But from my perspective, when we're going through the I-9, filling out section B, et cetera, we just have that available in front of us, right? So we definitely know that a document in list A establishes both identity and authorization to work in the United States. One of those documents is good. We're done. Proceed, go past go. Nothing else in that regard. But if it's on list B, we also need something on list C. Or if it's on list C, we also need something from list B. 2-3 items from list C, not good enough, because list C just says you're authorized to work in the United States. It doesn't establish your identity. List B only establishes your identity. It doesn't establish you're authorized to work in the United States. List A does both. Okay, so one item from list A or one item from list B and one from list C. And that's it. All right, let's see. We got a bunch of Q&A. So maybe I wasn't clear. I was ambiguous here. You want to go through some of these now, Rebecca?
Sure, yeah.
If you find an error on the I-9, can you fix it, or do you start with a brand new one after you complete your review?
Sorry, can you say it again?
Yeah, I'm sorry, that was too rapid. Yeah, if you find an error on the I-9, do you fix it, or do you start with a brand new one after you complete your review? right? So we're going through maybe an audit of one, et cetera, and we're looking at the I-9 and say, okay, there's an error here. Do we go grab another I-9 and have them fill out section 1, we fill out section 2, or do we make corrections on the original primary I-9?
Generally, you can just go ahead and fix the I-9 that you already have. It's gonna not be as pretty, but you can just do it in pen and then write, the date and then revise per self-audit. And that way you're tracking when it was changed, but you don't need to do a whole new I-9 again. It's fine to just go ahead and do it as a self-audit.
Good deal. I got a few more here I think we've got time for. They're good questions. If an employee provides you a copy of a Social Security card and you're notified when you file your quarterly taxes that the name does not match the Social Security number, none of us have dealt with this one before, right? Yeah, this one pops up all the time. Okay, so somebody used a Social Security card as one of their documents for their I-9, and then we get a little notification that that number doesn't match that name. What do we do, Rebecca?
It's a tough situation. The Biden administration had stopped the practice of issuing, some of you on this call may remember or have received a Social Security mismatch letter. There was a bunch of different guidance and different perspectives, honestly, attorney to attorney on what to do with those. Especially again, in our state, we have that push and pull between what an employer can ask and what the federal law is asking and requesting of us. We may see more of those Social Security mismatch letters in this administration. I haven't seen one yet. Have you, Andrew?
No, not yet. Surprising. I'm surprised that I haven't, but yeah.
Generally, when you get those, like, it's a batch letter, and sometimes it happens with your healthcare insurance too, there'll be a mismatch. Generally, and again, we need to take a look at the document that you've received to talk about it in detail. But if it's not a formal Social Security mismatch letter, generally employers don't respond to those individually. And kind of, you're not sticking your head in the sand, but there can be a whole host and multitude of reasons why an individual's Social Security doesn't match what they gave you historically. Maybe it's changed, maybe it's been updated, or for whatever reason, there's a typo on your end. So generally, if it's a batch letter like that, my guidance and advice is to just move on from it. Andrew, I don't know if you have different thoughts.
Yeah, I think that's good. It's very, very, very case to case specific, right? And even attorney to attorney specific, if not at least firm to firm specific. So that's one of those phone calls usually. And I hate to kind of sell that out that way, but like, you really need to know kind of what the stakes are, right? Who's notifying you of what the deficiency is and what our alternatives are. Okay, there's a few more questions there, but I think we can get to those within the body of the presentation.
Yep.
And if not, team, shoot us an email, etc. All I want to say on this examination of the documents is I just want to point to sort of the legal standard here, is that the documentation reasonably appears to be genuine and relate to the individual. Okay, if you receive a Social Security card that's red, okay, it's probably not reasonable to think that it's genuine. I don't know. I've never seen a red one. They seem to be bluish or bluish purple if you're colorblind to me, right? If United States is spelled wrong, all right, it's probably not reasonable to believe that that is genuine, right? If the individual in front of you appears to be between, I don't know, 20 and 40, and the picture looks like someone who's 80, I don't know, it might not appear to relate to that individual presenting it. I mean, outside of those, which seem like hyperbolic extreme examples, like a lot of the documentation that you receive will reasonably appear to be genuine and relate to the individual, like period. That's all you need to do. That's all you should do. That's all you're legally permitted to do. A lot of times I would say I hear stories about folks who are sort of hypercritical about the documentation that's presented. And technically that doesn't comply with the legal standard of accepting what reasonably appears to be genuine and relate to the individual. Okay, that's it. That's where the inquiry stops from my perspective, and I think legally. Rebecca, if you want to tone that down from the advice that I've given there, please do so.
No, I think the next slide kind of gets us into one of the common questions that flows from the conversation you were just having, which is copying the documents. And I have employers that do both ways. Some folks prefer to have a copy of all the documents that the employee went ahead and presented. I will say the majority, all of my practice is ag, but the majority of my clients do not go ahead and take a copy. Andrew, you're nodding your head, so it sounds like you're in the same boat as me. Because then you're in a situation where an immigration official whose whole job is to look at these documents can pick apart a photocopy of what was presented to you, and they may have a much different opinion of it than you do. I will say, regardless of what you decide to do, make sure the practice is the same across the board. If you're photocopying for everyone. Regardless of what flavor of document they're presenting to you. If you're not photocopying for anyone, regardless of the flavor of documentation. I don't know that anybody's using E-Verify, so I think we can skip beyond that.
And folks, there are a few questions in here. They're very good questions. I don't mean to lump them together, but for the sake of time, at least for this presentation, they seem to deal with going back at if documentation expires. So if the documentation in any of the lists has an expiration date or validity date, et cetera, and we've gone beyond that, what do we do in terms of re-verification, et cetera? And I think we'll get into that right now. So I'll defer to you, Rebecca, because you kind of handled some of those questions initially, but.
Yeah, that's actually the next slide here. So there is an option just for re-verification and rehires in ag. We have a lot of seasonal employees. So some people go ahead and use this supplement B for rehires. That's completely acceptable so long as the rehire is within 3 years of the original date of employment, and you're also updating the employee's biographic information. You can also just have the employee complete a new I-9. This is a determination for you to make as a company which method you prefer. I will say if you're doing a whole new I-9, we'll go through the time process for purging those. If maybe there's been some mistakes historically, if you're going ahead and using a brand new I-9, once that old I-9 is no longer required to be kept, you can get rid of it and it's no longer a potential violation for you. It's maybe one reason in the box of not using supplement B and just having folks go ahead and do a new I-9. You can go ahead and purge them, and we'll get into that timetable. But on to re-verification. So you are going to be re-verifying any employment authorization document with an expiration date. This is just authorization documents. It's not like if their driver's license expires, if their US passport is expired, you don't need to re-verify those. It's only if the work authorization document, for example, the form I-766 or the form I-94 with a temporary I-551 stamp, if those are set to expire, you should have in your system an ability to track those, and when it's about time to re-verify, potentially a tickler on your HR team's docket to go ahead and look those things up again. Those are the only things you are going to be re-verifying, nothing else. We've gone through this a little bit, but if you see in a self-audit that you have mistakes, if it's a mistake in section 1, the employee is going to make the corrections. You would just call them in and say, hey, there's just a mistake on the form I-9 we'd ask you to make. And if it's on section 2, the employer is going to go ahead and make those corrections. You're not going to use liquid paper. You're not going to white it out. You're not going to strike it through so that it can't be read. You'll just make them in pen, initial, and date, and include the words per self-audit, so that if you are facing an I-9 audit, the officer who's reviewing them can see that there was a self-audit, the company made proactive steps to go ahead and update and fix whatever the issue is, which will get you less fines and penalties when you've made those corrections. I want to be cognizant of everybody's time here and get to, I know, a question that we've had on retention. And this is a hot topic. Once an employee is terminated, you retain the I-9 for at least 3 years from the date of hire, or at least 1 year from the date of termination, whichever is later. So it's an or test, you're doing whichever one is later. And this is an issue that I've seen for employers before. If it's a seasonal rehire and you're processing them as a quit, termination, separation at the end of that season, and then you're having them do a new I-9 when they come back, those old I-9s you can start to purge once it's 3 years from that date of hire. So if there's an issue and maybe we weren't following our SOP historically on I-9s, you can start to trickle out and phase out those old I-9s and not have to hand over evidence of non-compliance once that date has come to pass, and you can purge those. And then there's some examples here as well, but you'll have this slide deck so you can jump to it as well. Again, we want to be cognizant of everyone's time. As Hannah mentioned at the beginning, we have an ICE inspections and immigration activity checklist that how's that best, Hannah? Should I put that in the chat? It's a PDF document. We'll make sure that you get that. And then we also have an employer resources emergency response website that we'll make sure that you guys all have access to and a link to. It also has emergency 24-hour access number that gets you on the phone immediately, regardless of time of day, with one of our attorneys in the rapid response team. Please use the phone number if you have an active raid happening, because it's a real phone number that is manned, and you're going to get someone from our rapid response team who's able to help you immediately. So if it's an active raid, you can use that phone number.
We
Go
can
ahead,
put it in the chat as well. I can send it out afterwards for the people that had registered.
Perfect.
In case people had to drop off.
And then Rebecca, do you just want to put up the 8 best practices slide about 2 or 3 down? As like teams like this would be the one that there's no homework here, right? This is all voluntary, etc. But this is sort of a nice takeaway as use kind of a checklist as well. I mean, Rebecca mentioned the formal checklist, but this is sort of a nice, I like to think of how are we doing? What's our status right now, right? You can kind of gauge, where you're at and where we might recommend that we want folks to be in terms of these issues as well.
And one more word on that push and pull between California and Fed. In California, remember that we have a labor code section that employees have a protected right to update their personal information, which includes a lawful change of name, social security number, or federal employment authorization document. There's a couple legal aid groups also that have a sample request that I've seen circulated and come through employers from time to time that says, I'm an employee in California, I have a right to update my personal information under 1024.6. This is my new updated information. So you'd want to go ahead and do that under California law, but I'm happy to, and Andrew, I'm sure, is also happy to talk through specific instances because every instance is a little bit different in how to handle that. Yeah. And then I'll put up our contact information again. So we're happy to get in touch with you and answer any follow-up questions you may have.
And thank you, everyone. Thank you for all the questions. For the ones we didn't get to, I apologize, just time constraints. We want to be cognizant of everyone's time, but we're happy to answer those, offline, etc. We don't mean to cut those short. There were some good questions in there we might not have gotten to.
Yeah, this was excellent. Thank you guys so much. And thank you for everyone who attended. And we'll be looking for more topics, more hot topics that you guys might be interested in. And we can continue to partner with Rebecca and Andrew on those. And we're really excited to have this partnership. It's so helpful. It's so beneficial. And I know it stirs up a lot of questions in your mind. So please connect with them afterwards. If things come to mind, or if you bring back things to your office and other people are asking questions and want additional information, they're an available resource for you guys. So thank you guys so much. This was fantastic.
Thank you very much. I'm putting a couple of those resources that we mentioned in the chat right now, but thank you for the opportunity to speak with everyone. Andrew and I both really enjoyed it.
Awesome. Thank you guys. Everyone have a great day.
Thank you. Bye.
Bye.